Manever I say ma PENDREAM TV. PENDREAM TV there, o see them yopo.
Mema wakwaba e de ba PENDREAM TV so make sure say obe subscribe to channel no click bell so say the news to our sabe to me aka ntem no watie afa so make sure say obe like na wa comment no share ama afoforo so nsaka na comment section ho so no opese wo kire wa adwen obetimi e de wa adwen kire ato honom na amanfo so anya bia kenkan na onim say PENDREAM TV there eye nsem a ekoso Ghana yam politics mu ne de ba na yasaka ya ne de abranti na so me video I saka pese no che na ye de ba nti me mo modern astro so obehwe video we amana si awie na wa kire wa adwen e comment section na se yenko video.
Now what made it more murkier is that you can also not be engaging an accused person you are prosecuting viciously in court at the home of a judge. And I'm saying that if I am the Attorney General, I would never have engaged in such a conduct. Whether the meeting was for domestic matters or for matters related to a matter that I'm prosecuting in court, I wouldn't have done that. So it was indeed for a certain purpose. Because if you marry these facts with the fact contained in the WhatsApp message that he exchanged with Jakpa, when Jakpa said, I would love to have a meeting with you. And then he responded by saying that I will arrange that through your brother. It means that meeting that happened at the home of Justice Yoni Kulendi was at the instance of the Attorney General. He arranged that meeting. He arranged that meeting.
Which meeting is this? The one at the Supreme Court Justice House?
Yes, the one at the home of the Supreme Court.
Who arranged it?
The Attorney General did.
What's your evidence for that?
The evidence is that was his message. That was his response to Jakpa, who said, I want to meet with you.
Where's that response?
That response is in evidence.
Where's it?
You haven't seen the WhatsApp communication. Nana, you are not following this matter.
We put it on the
screen. It will be on the screen. You are not following this matter.
Not all the time.
You see, so...
Yeah.
No, go on.
So you see, Jakpa said, I'm requesting for a meeting at a time and venue of your convenience. So who chose the time and the venue?
So who's saying this?
Jakpa is saying this.
That he's requesting for a meeting at a time and venue.
A venue at your convenience to meet.
And what was the AG's response?
The AG's response will come pronto.
What did he say? That let's meet at the judge's house?
I will arrange that through your brother.
Yeah.
I'm sure they'll
yes.
Okay. You go.
I will arrange that through your brother. Mm-hmm. So, Randy, we are saying that all these matters put together, the AG has put himself in a compromised position in terms of his professional work as a prosecutor, as an Attorney General, a Minister of Justice. And he has reached...
Just to be clear, sorry.
Yeah.
These are arranged that through your brother. Was it after the first meeting at the Supreme Court Justice House?
Right now, we don't even know the sequence.
Okay.
Yes, we don't even know the sequence.
So we cannot be conclusive?
Yes, but we can only conclude that this meeting took place.
Which one?
This very meeting. Because they themselves admitted to having a meeting with him.
But we don't know if this correspondence came after the fair, because the AG is saying, I will try and arrange something through your brother.
Through your brother.
That you could also infer that.
So then I can see that
the AG has now got to know that Jakpa is a relative of the Supreme Court judge.
In the recorded conversation, Jakpa made that point.
Yeah.
Yes, Jakpa made that point.
So the AG will now say, well, let me try and see if we can meet again at your brother's
So
house.
what I suspect is that even prior to these WhatsApp exchanges, there has been some other engagement.
There has been some meeting.
Yes.
That's the first meeting.
But whether first or second or third, there has been some prior arrangement and engagement. Because for the AG to say that we arrange through your brother, the brother in quote here means Justice Yoni Kulendi.
But what the record show, or what we know, is that there has been only one meeting.
Now, when you say meeting, I'm sure you're referring to a physical meeting.
Yeah.
Because we can have various forms of meetings.
Yes.
Yeah, I'm referring to a physical meeting.
Yes, but Jakpa didn't say physical meeting. He said meetings. So you could meet, and it doesn't have to be a physical
It could
meeting.
be a Zoom meeting.
Oh, you could meet on the phone.
Really?
Yes.
A phone call is a meeting.
What's the meeting, Anna?
A meeting is a meeting.
First,
If on this show, if I called you, I'm not having met you. I'm spoken to you.
I'm saying
we can do online meeting.
A meeting is not just
You are
a
a modern
physical
man.
meeting. That's
You are a modern man.
But the most, I don't even, we don't even have to split hairs here.
Yes,
The most important thing is that outside all the talk from spokespersons and deputy AG and political actors and whatever, now there's a deposition in court, which says that there are meetings. I want to be given the opportunity to provide the evidence and be cross-examined on same. Is that not the case? Rox, is that not the case?
That's the case.
Yes.
Yeah.
So, Randy, let me further my point.
Because at least if you even look at the one that refers to a meeting at the judge's place, that even creates the impression that there was only one meeting.
Yes.
And the meeting was at the instance of so and so and so. Now, even before, from what we know now, we know that there obviously has been more than one.
You see, I am hesitating in dealing with the contents of the affidavit filed. You see that I'm only relying on the
And your reason is?
Because it's not been taken through the motions in court.
But the other things that you are relying on
is the affidavits, which are now former court records. So he's relying on those public records and the AG statements and other documents. But the content of the affidavit are deposed to, I'm not relying on that one. That one, I want to leave it to the lawyers to handle in court.
No, I only refer to it because it suggests that the person is ready.
Yes.
For the allegations to be taken through.
Yeah, the allegations that he's made.
Yes.
Yes. So Randy, the points we are basing our call for his dismissal or removal from office is because he's breached about 13 different rules of our LI 24.
By doing what?
By the conduct.
By engaging.
By the conduct that he's engaged in.
Okay.
As the chief state prosecutor of the Republic of Ghana in respect of this
So
matter.
it doesn't matter whether it's a meeting or a telephone conversation or a WhatsApp chat or whatever. To the extent that there is an interaction.
Look, I can give you instances. The fact that he even issued a statement, first of all, denying the existence of that fact, which fact later he came to admit alone is a basis for it, because he's not been truthful. As the foremost lawyer in this country, Rule 8, that is conduct of a lawyer in public office, Rule 8 obligates him to be truthful and candid at all times. He didn't do that with his statement on the 24th. 2, Rule 13, which says that he cannot have communication with a represented person in a matter.
His spokesperson
Yes.
said on this show on Monday with Annie.
Yeah.
Sorry, that at the time that he met the third accused person, he didn't have legal representation.
I'll deal with that point. Where is the evidence of that? Where is the evidence that Jakpa didn't have legal representation? In any case, Rule 72 says you cannot make communication or contact a witness who is testifying, who is giving evidence in court. You can't. So even if they assume that he didn't have a lawyer, so they can make contact with him, which is also a further admission of what has happened. Rule 72 says you cannot make contact with a witness who is giving evidence in court in a matter you are prosecuting. You can't. So whether they run to the left or they run to the right, they are caught by the rule. His conduct, it's offense Rule 72. Now, other rules such as Rule 56, and Rule 35, and Rule 57. He has a duty to disclose. So the question we are further asking is, all the engagements he's had with Jakpa, did he disclose it to the judge in court? He did not. It took Jakpa to make these disclosures. It would have been concealed. And all this happened because of his temperament. If he were not angry and interjected the proceedings and made these unguarded comments about Jakpa seeking to defend A1, this country would never have known that Godfrey Dami has done these things. Nobody would have known. You are aware that in my matter before the Supreme Court, as soon as I filed the injunction, it's on record that he approached the Chief Justice for expeditious hearing. You are aware? You are aware? I've been asking him that the letter he wrote to the CJ for the expeditious hearing, I want a copy. He's not been able to provide it. And so in my matter, as soon as the injunction was refused, the matter is in abeyance. He hasn't taken any further step. He hasn't filed any further process, apart from filing affidavit in opposition to the application or notice for the grant of an injunction. He's gone to sleep ever since. Meanwhile, you claim that you have written to the CJ that the matter be expeditiously heard. So these are the things that he's been doing. And we are all grateful to Jakpa for exposing this one. This is the tip of the iceberg. And Godfrey Dami must step aside